Welcome to another episode of On the Issues with Alon Ben-Meir. Today's guest is the Honorable Lise Pearlman, a former California trial lawyer and first presiding judge of the California State Bar Court. Following her retirement from the bench, Judge Pearlman has become a best-selling author and nationally recognized speaker on famous 20th century trials, whose books have won multiple awards in the categories of law, U.S. history, and multicultural nonfiction. In this episode, Alon and Judge Pearlman discuss her book, With Justice for Some, Politically Charged Criminal Trials of the Early 20th Century That Helped Shape Today's America, and a few of the significant cases detailed within. The murder trial of Black Panthers founder Huey Newton, the Scottsboro Boys, and Sacco and Vanzetti, and delve into the injustices surrounding each trial and how they have impacted the American legal system.
Good morning to you, Judge Lise Pearlman. What a great honor and pleasure to have you today on my podcast. What's your background, what you have to say? It's really still even, of course, some of the cases you speak about though happened many decades ago, shed tremendous, incredible light on what's happening still today in American jurisprudence. So before that, I would like just to give a brief introduction as to who you are. The Honorable Lise Pearlman was the first presiding judge of the California State Bar and a former California trial lawyer. Following her retirement from the bench, Judge Pearlman has become a filmmaker, bestseller author, and nationally recognized speaker on famous 20th century trials, whose books have won multiple awards in the categories of law, U.S. history, and multicultural nonfiction. Pearlman's latest book, the Lindbergh kidnapping suspect #1, The Man Who Got Away, was Amazon #1 bestseller in criminal evidence in December of 2021. Again, thank you so much for coming on this podcast, and I know that our audience will be enlightened to hear what you have to say. I just want to tell you that I'm obviously not an attorney, so I might very well object to my own questions in the end. But nevertheless, I'll be happy if I don't find myself in contempt of court in your court.
No.
So let me ask you the first. In your book titled which is With Justice for Some, you revisit a series of landmark criminal cases that captured national attention and left a lasting mark on American society. Drawing on decades of historical scholarship and newly examined evidence, you explore how prejudice, media influence, and public sentiment shape legal outcomes long before later investigations challenge accepted narratives. To demonstrate that, I selected 3 major cases that you have so skillfully tackled. So let me just give our listeners just a very brief of the first one, and ask you, of course, to take all the time you need to elaborate and talk about the implication. And as a judge and a filmmaker, you brought the case to life on big screen on October 2020, 1967. Police officer John Ferry pulled over a car in West Oakland. Behind the wheel was Huey Newton, the co-founder of the Black Panther. Newton exited the car, a struggle ensued, and a few moments later, the police officer Frey lay dying on the pavement from a gunshot wound. And Newton fled. Later, he turned at a hospital with a bullet wound on his side. Newton was charged with Ferry's murder. The defense put the high-profile hearing to put racism on trial. Newton and his attorneys invoked the history of slavery and police brutality against Black people to put the shooting in a wider context. The Newton trial has transformed, and this is so critical, transformed the American jury of one's peers from the traditional 12 white men to the diverse panels Americans often take now for granted. So this is an extraordinary case. So please, the floor is yours. Can you just tell us about the case in more details and its significant implication
Well,
onto the formation of juries?
definitely, I'm happy to do so. The Newton death penalty trial took place in the summer of 1968, following the assassination of Martin Luther King Jr. and a couple of months later, the assassination of Senator Bobby Kennedy.
Right.
So it was a very tumultuous year in American history. And the Panthers demonstrated all during the pretrial period with the slogan, "Can a black man get a fair trial in America?" And up until then, they assumed not.
Right.
And he had excellent radical attorneys who wanted to challenge the traditional jury. That was a big focus because if it was 12 white men, they assumed that the generally white men were more uh, associated with law and order and would be more likely to want to vindicate the police officer. They thought they would have a better chance if there were minorities and women on the panel, which was not common at all. And so what they worked really hard. They put sociology professors on the stand to educate the judge. This was brand new,
Right.
talking about an inherent bias. And they wound up with a jury of 7 women and 5 men. Four of the jurors were minorities,
Great.
which was also unheard of. So this was a revolutionary jury. And the jury decided to pick the one black man in the panel, a banker, a David Harper, as their foreman, the first black foreman known to have ever been chosen in any major murder trial in America. David Harper was the person that fascinated me about this story. And I first learned about him because a book was written a year after the trial called A Special Rage, which included the author having tracked David Harper down and found out all the machinations of the jury, what had happened in their deliberation, which is very unusual. So I included that in the book, which wound up the jury wound up deciding there was fault on both sides, that the officer had been abusive, and that Huey Newton overreacted. And so they wound up not convicting him of first-degree murder, as almost everybody assumed would happen, but only voluntary manslaughter. And instead of riots, which had been predicted at the outcome of the trial, there was peace, except for 2 police officers who shot up Panther headquarters and were immediately suspended. Um, During the deliberations, the jury could look out the window where they were deliberating and see men with rifles on the rooftops around the court. This was the police preparing for riots, and they could see that as they deliberated. David Harper was the very first person we interviewed for the film when we made the documentary, which became a semifinalist for an Oscar. That was He was in his 80s, and I had just found out that he was still around by
That's
by
amazing.
accidentally meeting his niece. And unfortunately, David died this past weekend. He was 92. But we've kept in touch over the years. And actually, there was a David Harper Day in Oakland in his honor several years back. But because of what he did to get the jury to come together and focus on the evidence and not on external pressures, a book was written about a different book was written about the trial called Minimizing Racism in Jury Trials, about how that jury was picked. And that became the Bible for criminal defense lawyers nationwide. And that is really what galvanized the diversification of the American jury that we expect to see today. So that when George Floyd, for example, when he was murdered, that jury was very similar to the revolutionary jury in 1968, but it wasn't revolutionary now.
Yeah, that's it's fascinating. Can you, Judge Perlman, to elaborate further on how the case actually was a process went through the court system, and how they eventually the judge came to the conclusion that he has.
Well, the jury came to the conclusion based on conflicting evidence and the question of there was one surviving officer, it was a backup officer who was shot, and he testified, but he didn't see Newton shoot the other officer. He saw that a gun had fired in that from that general direction. The other two were grappling with each other when the gun went off, and the jury tried to reimagine how everything went down, and they came to the conclusion that Huey had been on basically almost kneeling at the time that the bullet hit his stomach.
Mm.
Um, and that must have meant that he was pushed down by the officer, and um, that was part of what their analysis was, that he shot back rather than shot first.
So basically, now Newton was shot on the side by the officer.
He was shot through the stomach. He almost died. One of the things that the Panthers were advertising was that Newton was taken to the hospital. He went to the hospital and was on a gurney on his way into life-saving surgery when he was shackled to the gurney and arrested for murder. So that picture of him on that gurney in great pain was something that they used to great effect to get support.
Was it established who actually fired the first shot, and how did Newton was able to wrestle the gun from the officer to shoot him? Was that how the sequence went about?
Well, that was what the jury assumed. We don't have actual, there's no video back then.
Right.
So we don't know exactly how everything transpired, but they did go back into court a couple of times for additional instructions. And one of them, they asked to have Newton lift up his shirt and show his wound that went in his stomach and came out his back. And that was part of their analysis as the angle of that wound. They also relied on the state ballistics expert, and his analysis of the bullets.
I see.
Um,
So what are some, I'd like to just to elaborate a little bit about the 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 ins and the outs that has taken place in the court itself. That is for the defense to make their case and to convince the jury and of course the judge that Wilson Newton was not guilty and he was in manslaughter instead of assassination. So some of the intricacies that evolved that had took place in the court. Can you elaborate a lot about that and how the defense made the case and were able to that is the emphasis on the time of the there was no fair trial. Why jury can possibly will definitely will convict a black suspect or criminal. So the trial has changed that major aspect of the selection of jury. Can you just tell me how the jury that eventually was selected, how this came about, and some of the deliberations that have taken place?
Sure. The juries up until that time, one of the criminal defense lawyers I spoke to said they just picked the first 12 people that didn't seem to have two heads or a definite bias because they were good friends or relatives of the prosecutor or, had a conflict. Um, Gary had a different attitude. Charles Gary was a very well-known criminal defense lawyer who had never lost a client to the death penalty. And he was quite determined to basically verbally attack any potential jurors that he thought might be biased, and that usually was white men.
Right.
So it was a very famous question and answer period for one white gentleman who the judge excused for cause ultimately, but it was a big battle to get to that point where Gary finally got the man to admit that he thought Newton was guilty already just looking at him. Um,
I see.
so that would disqualify him. Is he presumed innocent? But you don't believe that, do you? And the guy said, "No, I don't." But when they chose that jury, he was not, Gary was not pleased with all the options he had. There weren't that many minorities in the jury pool. There were women in the jury pool, and some of whom he didn't really trust, and he basically didn't trust the white men in the pool. They wound up with two white men, a young man in his 20s and an engineer in his 40s. And then they had a Latino man and an Asian American man. Um, and the women, a couple of more housewives, there were different ages from 20s to their 50s. Um, and he had to settle for what he got because they each had 20 challenges on each side that they could use for no reason. It's called peremptory challenge. And he used all of them. Whereas the prosecutor had a different strategy. The prosecutor, Jensen, who I interviewed for both the book and the film, and he actually read the whole manuscript before it was published and told me it was the definitive book on that subject. He trusted women, and so he didn't have a problem putting women on a death penalty case, although the studies had shown that white men were more likely to want the death penalty than women were. Um, but he definitely wanted one black person on the jury because he was afraid that otherwise Gary was going to take an appeal arguing the bias in the, getting rid of every potential black juror. In fact, the week before, that had happened in another case where a mistrial was declared because of the prosecutor's conduct. So he definitely wanted one, and he liked David Harper, who was a pioneering banker and had already sat on other juries. But he actually left 5 or 6 challenges unused. He was happy with the jury composition, and Gary was nervous. Um,
Right.
it took them from a Thursday that they when the jury was instructed until Sunday evening to deliberate, and each night they would stay at a different hotel for protection. Um, but every day, the courthouse was surrounded by Black Panthers and supporters yelling, "Revolution has come, time to pick up the gun. Um,
Right.
the sky's the limit." Um, but he was amazing, David Harper, in getting the jury to focus on the evidence and take it step by step what they thought happened. And they wound up basically deadlocked on Sunday, and he thought he had failed. He did not want to have a hung jury, which would mean there would be a second trial. Um,
Right.
and so he tried one more time, and the others said, "Let's vote again." And they wound up all voting for voluntary manslaughter. Before that, there had been several votes, and a couple of them wanted the death penalty, a couple of them wanted second-degree murder. There were 3 votes for acquittal, and then others for voluntary manslaughter. So it was a wide range. But they ultimately agreed that the officer had instigated with abusive behavior, and that was part of the trial testimony that showed that he was abusive in general with other arrestees. And Newton had testified that he'd been abusive toward him. So they believed that. Um, and they were able to separate their feelings about the Panthers in general, partly because Newton was allowed to do something very unusual, and that
Right.
is the judge let him get on the stand and explain the history of the Black Panthers and the history of racism in America, which had led to the Black Panthers being created, over the objections, numerous objections of the prosecutor. But it put in context the confrontation that had occurred.
That's very fascinating. So, without concern about incriminating himself being on the witness stand. So, has the defense volunteered that, or just Newton himself just decided this is the best way to go?
Well, it was both. He and his lawyer realized it was risky because when you put a defendant on the stand, you don't quite know what's going to happen. He was examined at length about what happened that morning, but he did really well. And that was a day that the courtroom was overcrowded. Everybody wanted to see Newton on the stand. And the fact that he was able to turn to the jury and start lecturing them like a professor about American history was amazing. When he was in the courtroom, he was allowed to dress in street clothes,
Right.
which didn't always happen then, but the judge allowed that. And so his older brother, one of his older brothers, got him outfits that he wore, and he looked like a professor with a turtleneck and a jacket.
Yeah.
Um, and he spoke very calmly.
That's a great. So can you just tell me finally on this particular case? So how long did it take from the time he was arrested until he was sentenced, and what happened subsequently?
Well, he was arrested immediately in the hospital right after the confrontation in October of 1967. He was jailed up until through the trial, which ended in September. He was sentenced later that month in September and sent for 2 years minimum to prison for the voluntary manslaughter. He was released in August of 1970. And there was at that point, because of the Court of Appeal had reversed and remanded for a new trial based on arguments made by the co-counsel Faye Stender, who was a pioneering woman criminal defense lawyer working with Charles Gary. And so he had to face two more trials for voluntary manslaughter, both of which ended in hung juries. So the only jury that actually reached agreement was the first one.
I see. And subsequently, so he was released, and what happened to him?
Well, eventually he was released at the end of that. The case was dismissed. Um, and he went to Cuba in 1974 for 3 years. He came back. He went to Santa Cruz and got UC Santa Cruz and got a PhD
Oh,
based on the FBI investigation of the Panthers and actually persecution of the Panthers. Um, and he wound up taking too many drugs. He was he had a meeting with a drug dealer in August of 1979. I'm sorry, 89, um, and was shot and killed.
wow. Mm. And so that was, so he died in
And he
1989.
was unarmed then. He died in August of 1989. And it was right near where the original confrontation had occurred with the policeman. There is now actually a Black Panther museum in Oakland, and there's a bust of Huey that has been erected near that street corner.
I see. That's a fascinating. Um, the other case, which I found really, really heart-wrenching, just incredible, and that is the Scottsboro Boys.
Oh,
Uh,
wow.
yeah. Let me just tell our audience what is this case is briefly. The case of Scottsboro Boys, which lasted more than 80 years, helped to spur the civil rights movement. The perseverance of the Scarborough Boys and the attorneys and community leaders who supported their case helped to inspire several prominent activists and organizers. For the movie and the To Kill a Mockingbird, the Pulitzer Prize winning novel by white author Harper Lee is also loosely based on this particular case. This is an amazing case, of I guess about 10 or 12 black boys. So I'm going to leave it to you because this is absolutely one of the most fascinating cases I have ever read. And I would please tell our audience what this was all about and what happened subsequently.
Well, this was during the Depression, and there were a number of uh, youths on this train. It was a freight train. They didn't have money for
Right,
seats in a regular passenger train, and they were coming through uh, Arkansas. And what happened was that some white boys on the train picked a fight or got into a fight with several black boys on the train, and most of them, I think all of them actually, wound up jumping off the train when it stopped. Um,
right,
but when the police, the local sheriff and his deputies, were asked to go back to the train to arrest whatever however many black boys they found on the train, because the white boys who'd gotten off went and complained that they'd been attacked. So they went there and they found that there were 9 black youths in different cars, still on the train, minding their own business. And there were 2 white women. One of them was a 21, and the other actually was a teenager on the train. And the 21-year-old was afraid that she was going to be arrested for violating the Mann Act. The Mann Act had been enacted about 20 years earlier, which prohibited the transportation of women across state lines for immoral purposes.
I see.
And both of them were involved in prostitution.
Yeah.
So
Yeah.
she thought she would get arrested. So she told the police, the sheriff said that they had been raped by these young men. And the other young woman agreed with her.
I see.
They were actually examined by a doctor and they hadn't had sex recently, but that didn't come out. What happened was that there was a state fair in Scottsboro, Arkansas, which was nearby as the county seat. And people locally started whispering about this horrible attack on these young women, and they wanted a lynching.
Right.
They
Yeah.
thought that would be a great celebration of the Scottsboro Fair, is to lynch all these young men. Well, the sheriff actually, Matt Wan, did not permit that. He stood by them with his deputies and his gun and said, no, they're going to go to trial. Well, the trial was absurd. The judge appointed a lawyer for them, but they didn't have a competent local lawyer. They took a lawyer from out of state who was a real estate lawyer, didn't know anything about criminal law,
Oh, wow.
and said,
Yeah.
you're going to represent them. And so they gave him as local counsel someone who I think was considered to be an old drunk, but he was a lawyer with a license. So they went to trial, and all of the trials back to back, one after another, lasted only a week.
Wow.
And it was immediate because they wanted at the end of the week to have their hanging. And it was outrageous. The first young man was, and they ranged in age, I think, from 13 to 19. But in any event, the first one was beaten and told that he was going to be executed unless he confessed. So he blamed the others and said that they had done it. There was no way that he should have the same attorney as all the others did.
But he didn't confess to the crime.
He did, but he was lying. He confessed to save his life.
I
It
see.
didn't
Okay.
happen.
Right.
And so at the end, one of them did not get the death penalty because he was too young. He had to be at least 14 to get the death penalty, but all the rest of them did. Well, this became a cause célèbre for the Communist Party in America, for their legal defense team, and for the NAACP. So there's a great deal of interest in this appeal. And it went up to the U.S. Supreme Court. And the U.S. Supreme Court decided that the jury pool was defective. The only people that could possibly serve on the jury were all white, even though there was a substantial number of black people who could have served. And they said that was improper, even though the state defended it, saying it wasn't overtly racist. It was because they didn't meet qualifications. But
Right.
what they looked at the history of it, and anybody's lifetime, they'd never had a black member on the jury. So they
Right.
said, we see how you handle this. That's not adequate. So that was one reversal. But the other, in a separate appeal, they also held, and this was the major result of this case, is that a defendant who has no money, which these young men did not, has the right to counsel, and the state has to provide counsel in a death penalty case that's competent. And their lawyer had not been competent. So that was the right to competent counsel, which they used it as it was a constitutional issue. that they declared for the first time in the Scottsboro Boys cases. It took another 30 years before the Supreme Court said that in other felony cases that didn't result in the death penalty, you also were entitled if you
But,
had.
but, but before you continue, this is 30 years, and then what happened during these 30 years? Where we the boys were held?
Oh, the boys were, well, they weren't, I'm sorry, the 30 years, well, I was just referring to the fact that other defendants in felony cases that weren't facing capital punishment finally got a Supreme Court ruling saying they're entitled to competent counsel from the state too, which is how public defenders' offices were originated.
Okay.
But during the time, you're right, during the time that the appeals were pending, all of the defendants were in jail. Most of them ultimately died in jail. One of them was ultimately released and he was pardoned many years later. But one of the things that happened when they had a retrial back in, uh, I'm sorry, it was Alabama. I did say Arkansas, Alabama, Scottsboro.
So
Um,
Alabama, yes.
Alabama. When they had the retrial, they got a really good New York lawyer. And what he did was he put a model train in front of the jury and showed them where the boys were. They were all in different cars, and that the girls who complained had been in a totally separate car. It didn't make any sense that they had all ganged up on them to rape them. And of course, there had never been any rape. And one of them was basically exposed as a liar in that second trial.
Yes. So because I mean, the story went on and on. So what happened with the various boys over the years subsequent to this?
Well, what happened to them that it ruined their lives.
Yeah.
Um, you know,
Because you said that between the nine of them, they served nearly 100 years in prison. Um, so and then I guess the youngest was not sentenced to death. He was released because of his age. Uh,
well, he didn't get death penalty. He still was jailed. But the ones that were facing the death penalty were um, kept in a jail where others were being executed on a regular basis. So they were listening to that happening, them being hauled off. It was psychologically, it was also horrible. And, uh, they were very frightened and they spent many years in jail.
Right. Judge Pearlman, you would think that the case we met earlier, we spoke about it, and this case, obviously in both situations, Black people were involved. And things might have improved since in terms of how, as far as you know, crimes committed by Black people. But to this very day, obviously discriminations against Black in the courtroom is still pretty much apparent. I mean, I was just looking at some statistic. For example, even today, 32% of the prisoners in the United States are Black, and 21 Hispanics are Black, where in fact the Black is only 13% of the American population, and the Hispanic 19%. So together they are 32% of the American population, but they are 53% of prisoners in the United States. So this legacy, this discrimination against Black, might have improved, but has not really changed. From your experience, subsequent to these events, have you seen other cases where that tradition of prejudice, blind prejudice against the Black, is continuing, continue to this very day, as far as I know?
Well, there's a book Michelle Alexander wrote, The New Jim Crow, which goes into that in great detail. You could have the same crime, and the prosecutors, who are mostly white male, and that's changing somewhat, but when she wrote the book, it was very evident, would use their discretion to charge more lightly a white man with the same crime than a Black man with the same crime. So there's that aspect, and the same true with Hispanics. Um, and the sentencing, juries also come down harder in general.
Right.
They find there are fewer, unfortunately, still fewer minorities who serve on juries. One of the problems with juries still to this day is that uh, if it's a long and complicated case, which means 2 weeks or more in a criminal case, um, people can be excused from jury duty for hardship. And if
Right.
you don't make a lot of money, if you're very, very poor, you get off the jury. So the juries tend to be made up of people who are retired, people who are work for institutions, people who work for large companies. Um, so there's that aspect to it. California has changed its rules to try to uh, increase the diversity of the jury panels. And San Francisco has an experiment where they're actually paying low-income jurors $100 a day, which
Right.
is very unusual. Some states it's only $15 a day for
Right.
jury duty. Um, and so there's that aspect of it. So you have a skewed jury pool that's more economically advantaged, fewer minorities, and that's still evident today.
So, as a judge, from your experience, if you've seen juries deliberating, is the system, appearing before a jury of people largely are not lawyers. They do not necessarily know the law. They are instructed by the prosecution, by the defense about the cases, and they go and deliberate and they come up with a judgment. From your experience, do you find that to be by and large fair? In the end, that is when you look at the whole situation, that the jury system is working well, because today we still have a jury. Am I right to say to think that in some cases they're using now only six instead of 12 as well?
In federal court, sometimes has six. It varies between civil juries and criminal juries, and criminal juries are generally 12.
Right,
Um, but the Constitution doesn't say what size they need to be. Um, and the jury of one's peers is actually something that comes from British common law. Um, but obviously, one of the things that has changed is the composition of the jury is much more diverse in general than it was historically. Because for a long time, well, if you didn't have the right to vote, which women didn't have nationally until 1920, they weren't even on the list
right,
for a jury
right,
pool. Um, but that changed, but it's also broadened now. Now some states, you're they pick jury pools from driver's licenses and from other sources. It's not just the voter registration. Um, so it has evolved over time, but there's still lots of issues of unfairness built in. There are a lot more women judges now. There are a lot more minority judges. That's helpful. Um, and juries, I think, actually, when they're seated, they try to be fair. And one of the things that's been studied is that um, when a jury is diverse, it deliberates longer in general,
yes,
and it comes to results that are more defensible. And I think the reason for that is if you sit down with people who look and think like you overlook some things and you might not focus on all the evidence. You come with preconceived notions of how people behave, like like the trope of saying that Asian drivers are more dangerous or something, and you're in a civil case and you say, aha, that must be the case. But well, if you have a couple of Asian American jurors, you're not going to say that
right,
if you felt that, and you're
right.
going to focus on the evidence.
This is true. Yeah, I mean, of course, have to focus on the evidence. Their task in the end of the day, they have to decide on the case on merit. But I think, you're absolutely mentioning a very important point, that throughout the deliberation, they also try to learn about each other, the way they're thinking, why they're thinking the way they're thinking. That is without necessarily expressing that, but that naturally they want to know, because they're different ethnic group. Could be black, white, women, young and old. So the process of learning about each other also eventually lead to eventually deciding, whether the person is guilty or not guilty. So so from your perspective as a judge, the system still works and works well.
I think the jury system is a good system. Um, we'll see what happens with one of the things that has changed in California is almost entirely eliminating peremptory challenges. Peremptory challenges, which is for no cause, you can just say, I'll excuse Mr. X or Miss Y.
Right.
The that has been used to get rid of a lot of minority jurors too.
Yes.
And
Yes.
one of the things that has been criticized is that the prosecutors use proxies, the neighborhood that you live in, the way you dress,
Yes.
that you might identify with a minority defendant. And California has made a list of those kinds of reasons for excusing someone as prohibited, and that can come out. The judge can require that on the request of the other side, the prosecutor to say what their reasoning was. So it's much more limited now in California and maybe some other states, but that's also been a factor in getting rid of potential minority participants in the jury.
Right. So, as a judge, do you have a personal case, a specific case where you have faced these issues with a jury, with a minority being the accused? And what was your, I mean, did you have such a case that you can point out that sort of galvanized some of the things we're talking about? And from
Not
personal,
personally, but personally, because I was actually a civil
are you a
uh,
civil? Yeah.
lawyer, but I did serve on a jury that was very interesting in that regard.
Yes.
Oftentimes, because I had been a judge, they might not want me on the jury, but I wound up on this jury, and it
Uh-huh.
was just a case involving a man who was accused of driving under the influence.
Right.
Um, and he was black, and most of the jurors were black women.
I see.
And there were a couple of white men and myself. And we wound up with a hung jury. And the reason we hung was, I think, that basically the white men and me, because he said that he was recovering from an illness, I think, and had been as a pedestrian in an accident. So he was wearing a brace on his neck, which wasn't noted by the officer. Um, and the officer hadn't done all the tests he could have done because it was the end of his rounds to prove that the fellow was under the influence. And we didn't think there was proof beyond a reasonable doubt that he was under the influence. And so, but what was funny was one of the black women during deliberations, um, she listened to the defendant's story, she said, "Oh, I've heard that story before. Don't believe
Right.
him."
Right. Yeah.
So they were more skeptical. So you
Right.
don't quite
So,
know.
yeah, go ahead. Sorry, go ahead.
You don't quite know how people are going to react if they are in the same group. Um,
I don't ask this very sensitive question. No, being a white, another white that you actually did not find the evidence sufficient enough to find him guilty. Did you feel any sort of sense of mercy, pity? This is a black guy, was a drunk, and this is a sort of that is prejudice to the contrary. That is, we always hammer on the black people. Maybe this time, did you have that sense of, or you did really very, you adhere fully to the evidence? Do you feel that you had a different kind of, because you cannot avoid these type of emotions and feelings. I mean, this is a part of the psychological dimension of any deliberation. Did
I didn't really in that case. I mean, it didn't seem like there was any kind of bias in prosecuting him.
uh
It was what they thought the evidence supported. And three of us disagreed.
I see.
And that's what jury trials are for.
So, the other case I'd like to elaborate on, we have another 15 minutes to go. Hopefully, we can cover this one, which is very, very fascinating. So, this one is on May 31st, 1921. Nicola Sacco, a 30-year-old shoemaker, and Bartolomeo Vanzetti, I call him just Vanzetti, 29 years old, a fish peddler, went on trial for murder in Boston. More than a year earlier, on April 15, 1920, a paymaster and a payroll guard had been killed during a payroll heist in Braintree, Massachusetts, near Boston. 3 weeks later, Sacco and Vanzetti were charged with the crime. This was fascinating, although these were not black, but they were Italian. So I'd like you to speak to this. I have here written a statement by the defense. Perhaps I don't think it's necessary to read the whole thing, but just write. Just I want to write just the last paragraph of their statement that was published. They said the issue is not only for Massachusetts; it is for America. The world will judge America's idea of justice on this case. This case is vital to you, to all of you who are without friends, influence, or wealth. July 10, Sacco and Vanzetti are scheduled to burn in the electrical chair. A month from then, it may be you, if you agree with them that the organization of society is not perfect. So, can you tell us about this very interesting case and how this came about and how did it eventually came to a
Well,
conclusion?
this was just after World War I, and there were a lot of anarchist bombings that had occurred, and they were accused of being anarchists and handing out pamphlets that supported anarchism. And the judge was several generations back, Bostonian ancestry, who was very conservative and very patriotic. And he wanted the jury to convict them based on their anarchistic views. It didn't matter whether they'd actually participated in this robbery. They came to court in a cage during the trial. And the judge made a lot of hints to the jury about doing their duty. Because these men had fled to Mexico during World War I and not served in the armed forces. Um, it was very highly publicized by American Communist Party and overseas because the U.S. had emerged as the world superpower after World War I,
Yeah.
and how it handled dissidents and how it handled minorities, because it was something that the rest of the world was very anxious to see. And in this case, in the Boston area, um, Italians from southern Italy were treated pretty much like blacks in the South.
Mm.
Um, so they were much despised by the aristocrats and the powers that be. So it was uh, almost a foregone conclusion that they would be convicted. Um, After the fact, it turns out that one of them probably did participate and the other one might have been an accessory after the fact. But there was disputed evidence as to whether either one had participated. But it caused repercussions worldwide. The fact that they were convicted and sentenced to death, there were bombings around the world at the American embassies. There were demonstrations. I think the judge had a guard, I think maybe for the rest of his life. I'm not sure. But his approach to judging the case was so biased that it led to a lot of reforms in American justice systems. So it was a lesson in how due process needs to happen, which it didn't happen, and
Right.
fairness needs to happen, which it didn't happen in the way that trial took place.
Yeah, can you tell us, Judge Perman, about what happened in the court, a little bit of that, so that look at the whole case in the context, they are being Italian ancestry, they are anarchists, they went away, they escaped for 3 years, didn't want to serve in the military, so there was a high level of prejudice against them.
Well,
The judge was obviously strongly leaning toward conviction. He was sending clear signal, not even hidden, to the jury to convict these people. So,
one of
what happened
Okay,
inside?
one of the problems with the trial was how the jury was selected. The judge sent his bailiff around to clubs that he belonged to, and other civic clubs to recruit people. So it was not arbitrary and systematic.
Right.
They had no Italian Americans on that jury by choice. So it was not, that was, the jury selection was totally unfair. The jury was given uh, too many hints from the judge exactly what he wanted them to do. They had many witnesses for both sides. I think one of them was a fishmonger, and he said he was out selling eels at the time that they thought he was involved in this robbery. And there were other witnesses who said so. And it was it was a fairly lengthy trial. Um, and the it was obvious to observers that the prejudice of the judge was going to make a difference in the case, even though the judge was kind of careful in the language he chose to use, but
Hmm.
the emphasis and the way he said it made it clear what he wanted.
But the evidence that was produced by the prosecutor, was there, without any doubt? I mean, what kind of evidence have they produced to demonstrate without any doubt that these two, in fact, committed the murder? And
Well, yeah.
what sort of approach the defense has taken place to demonstrate otherwise?
Well, I'm having to recall now. It's been a while, but the prosecutor started out by zeroing in on their radicalism and avoidance of the draft, which had nothing to do
With the
with
murder
the
itself?
facts of the murder.
Yeah,
There had been four men involved in this murder. They had retrieved the car ultimately that was used in the robbery murder. Um, so they had that. Um, but the I don't know how to explain it, but basically there were conflicting witnesses in a 7-week trial, 160 witnesses altogether.
wow.
Um,
Huh.
uh, the prosecutor claimed that the gun Vanzetti had in his possession when arrested had been lifted from the payroll guard who had been killed. Um, that was a false assertion. The weapon was a different caliber than the guard had carried.
Right.
Um, Later, Professor Frankfurter, who wrote about this case before he became a justice on the Supreme Court, um, he noted that the judge's bias in skirting over the massive testimonial conflict um, uh, when he summed up the evidence made a difference. So there was all this conflict in the evidence, and he's pretending that there wasn't. Um, he overstated the state expert's opinion regarding Sacco's gun as the possible murder weapon, and invited the jurors to dwell on their behavior following arrest to assess whether it demonstrated consciousness of guilt. So if they resisted arrest, then, or if they were whatever, he was using their conduct later as indicating they must have been guilty.
Right. So how long did the jury take? How long did it take the jury to deliberate and finally they come up with a judgment?
They
I-
took less than a day to
Let-
find the two men guilty as charged. And the judge soon afterward was bragging to his club members, "Did you see what I did with those anarchistic bastards the other day?"
Right. And so what happened subsequently after
Well,
that?
they went on appeal. Um, the their conviction was affirmed and they were executed.
How long? How many months since, or how much time lapsed since
Um, I
from?
think it was my recollection is that they were executed in 1927. So it was a few years that they were in jail, getting a lot of support, letters of support, and people demonstrating. All of this happened after the conviction. There were not, like with the Panthers, there had been demonstrations around the courthouse during the trial. The Sacco and Vanzetti trial, the local police were concerned, and so they had reinforced the courthouse, but there were no demonstrations outside.
Now, having studied this case, Judge Pearlman, from your perspective, do you feel that they were in fact guilty of the charges of murder, or do you think there was some misjudge have taken place?
Well, I think that there's been a lot of study of the case ever since. There was proof later on that Sacco's gun, after ballistics tests, had been involved in the robbery murder, um, and that the fact that Sacco was complicit was confirmed by another member of Il Gruppo Autonomo, which is the group that he belonged to of anarchists. Um, but there was no similar proof of Vanzetti's participation.
But nevertheless, he was still sentenced to death and was in fact electrocuted.
Right.
Yeah. In conclusion, that I'd like you to give us our audience a sort of a general view as a judge. I look at the current situation in the United States. I don't want to get too much into politics, but the only institution that's still functioning today effectively, in my view, is the judicial system. That is, many of the things that the Trump administration has been trying to do, the various executive orders, and had it not been for the judges maintaining a sort of judicial integrity, things would have been considerably worse in the United States. Do you agree with this assessment of mine, and do you think the judiciary system could be further improved in the United States? As a summation of what your experience as a judge, your experience as a trial lawyer, and your obviously extensive research, and the number of books that you have written, not to speak, of course, the filmmaking, the documentaries that you have produced. On the whole, how do you see our judicial system working? Is it working well? And if there's any room for improvement, where would you improve it? From
Well, one way to improve it, it definitely could still use improving, is to encourage the continued diversification of juries, um, and to increase juror pay so that people who are poor can participate, which is a big problem. But I think that in recent years, you've seen people running in state elections for prosecutor who are not traditional. They're minorities and they're women, and they bring a different perspective to prosecution, which is good because they're supposed to be interested in justice, not in convictions. So that if it turns out that the evidence doesn't support a charge that they had made, that they would dismiss it. And if it turned out that they convicted someone who later it proves to be innocent, they would be helping in freeing that person. I have a daughter who specializes in civil rights litigation for
mm,
people who've been wrongfully incarcerated. And one of my other books, and it's mentioned in With Justice for Some, is about the Lindbergh kidnapping case, which still there are questions of whether Hauptmann was he was executed, but whether he was innocent, and whether he should be posthumously pardoned, which actually I'm working on because I think they made not just a mistake. I think he was framed. Um,
mm.
so there are issues like that, but they still go on. The Innocence Project has many clients imprisoned, still seeking their freedom. So there are lots of issues that can be addressed. Um, Still working on a lot of forensic experts need to be focused on. There are pathologists who are associated with both the police department and the prosecutor. They don't always have the independence they need to come to a conclusion that just doesn't support a particular suspect being prosecuted. So there's still issues.
Yeah, one final question about this. Federal judges are nominated by the administration, Republican or Democrat, and obviously Republican would nominate judges with Republican leaning, and the Democrat would do the same thing. Do you think that system is fair? And look, for example, what's happening today in the Supreme Court. Trump was able to appoint three very conservative judges. Today we have a majority in the Supreme Court who are Republican.
Well, I think that we don't.
Affecting their judgment and eventually, because we see this happening. Do you think the system is still valid, correct, or should that be changed? That judges should be appointed by high, commissioners of, legal experts rather than being appointed by the administration?
Well, first of all, when you're talking about criminal cases, 90+% of them take place in state court. So it's very seldom that you have a criminal case in federal courts where you have that. Up until recently, up until Trump, you had the ABA, American Bar Association, vetting judicial candidates and rating them. Now that's being ignored in favor of the Federalist Society. So there is a much stronger right-wing bent to the candidates that would be appointed by the president. You also have the Senate not really doing the vetting job that they're supposed to do.
Right.
So you have those issues. In fact, with Justice Kavanaugh, for example, President Trump directed the FBI not to fully investigate him.
Yeah.
As far as I understand. So you didn't have the vetting from different sources that you would normally have. There need to be reforms.
Right. I think so. We so quickly run out of time. I just want to tell our audience, the book With Justice for Sam. It's a fascinating book, and I recommend everyone to read it. Absolutely fascinating to go over these incredible cases that you are dealing with. Judge Pearlman, I want to thank you so much for taking the time. It was really a pleasure, and I hope we'll have another opportunity sometime to talk about your new book.
Oh, yes, be happy to. Thank you so much for inviting me.
All the best. Thank you again. Thank you again.
Okay,
Bye.
bye-bye.
Bye now. Thank you for listening to this episode on the issues. You can find this podcast on my SoundCloud page, and stay tuned to my social media accounts for the latest analysis and announcements.